Law of Torts. Today's subject is Essentials of Torts. My name is K. Umesh Rao. Introduction to Torts. The law of torts, it signifies violation of variety of rights and duties. And so, it is very difficult to give a complete definition of it. The law of torts is not a codified law, it is a judge-made law. It is based on the common law of England, which is unwritten and codified. It is an ever-growing law, and the courts are expanding its origin continuously by recognizing new torts. It is not possible to give a perfect and scientific definition of law of torts, which would include all its aspects. Now, essentials of torts: wrongful act and legal injury and remedy. What is wrongful act? It is an act which affects some person's legal right correspondent with legal duty. It may be an act or omission which gives rise to the breach of legal duty or violation of legal right. For example, causing willful injury, not respecting the property of others, not using due diligence and causing harm to others. What is legal injury? Legal damage. Violation of absolute right causes damage called legal damage or legal injury. These acts need not require proof of damage. They are actionable. All damages are not legal damages. There should be violation of rights. For example, trespass, assault, battery. And remedy. What is remedy? Remedy is unliquidated damages. So, damages or compensation is a remedy. Wrongful act. It is an act which affects some person's legal right corresponding with duty. It may be an act or omission which gives rise to the breach of legal duty or violation of legal rights. What is wrongful act? Not respecting the property of others or not using due diligence to avoid causing harm to others. For example, X constructed a building in his own land. X house obstructs the light to neighbor's house. Neighbor is enjoying the light since 20 years. Thus, damage is unlawful or injurious. Passage of servitude, easement, is on the field of Y, which gives right to walk or driving. Y has the duty to refrain from putting obstacles. And legal injury means legal damage. When there is a violation of absolute right, it is a conclusive presumption of damage called legal damage. These acts need not require proof of damage. They are actionable. Thus, all damages are not legal damages. These damages are of two kinds. One, damages damnum sine injuria. Another, injuria sine damnum. Now we will take injuria sine damnum. Means violation of a legal right without causing any harm, loss, or damage to the plaintiff. There is a violation of human rights, legal rights, but no harm, no damage, no loss to the plaintiff. For example, one person trespasses or enters into another's land and quickly he goes out there. He doesn't cause any harm or damage to the plaintiff. However, private rights, right of privacy affected by trespass of the defendant is violated. Hence, trespass to the land is actionable, even though no damage has been caused as a result of trespass. Another is example: A makes defamatory statement against B. There is actually no harm, loss, or damage, but still it is liable for remedy. So, in these cases, plaintiff need not prove that he has suffered harm, loss, or damage by wrongful act. He has to prove that his legal right was violated by the defendant. There is another clause, one more case, that is plaintiff entitled compensation on the proof of actual harm, loss, damage by the wrongful act. For example, negligence, nuisance comes under this second class of torts. Now, we will take up the case law. Ashby versus White. Plaintiff is a qualified voter in parliamentary election. Defendant was a returning officer. Defendant wrongfully refused to take plaintiff's votes. In fact, plaintiff's candidate won the election. Therefore, there is no actual damage suffered by the plaintiff. Plaintiff sued the defendant, alleging that the defendant did a wrongful act. The Court of Appeal held that defendant was liable and granted compensation to the plaintiff, even though there is no loss. Another case is the Bhim Singh versus State of Jammu and Kashmir. The petitioner, an MLA of Jammu and Kashmir Assembly, he was wrongfully detained by police and he was produced before the magistrate within not within the request term period. The member was deprived of his constitutional right to attend the assembly session. Supreme Court held that detention of the plaintiff was against the fundamental right of personal liberty guaranteed under Constitution. Supreme Court ordered to release the plaintiff and awarded exemplary damages amounting to rupees 50,000. Third case is Marzetti versus Williams. Banker refused to honor the check of the customer even though he has sufficient fund in his account. For refusing to honor the customer's check, though there is no actual loss or damage, it is held that customer entitled for damages. Next one is damnem sine injuria. Here damage is caused without wrongful act, damage or injury inflicted without any act of injustice, loss or harm for reason there is no legal remedy. That means damage is caused to the plaintiff, but there is no violation of his legal right. Damage without wrongful act. In these cases, damages might have been occurred, but it is in exercise of the legal rights. This action resulted into the harm to others. In view of the above discussion, we can say that tort is a civil wrong, but all civil wrongs are not torts. We will take some case laws. Gloucester Grammar and School case. The plaintiffs are maintaining a school. They charged 40 pence per student per quarter. The defendants set up a rival school near to the plaintiff school. Because of the competition, the plaintiff had to reduce their fees from 40 pence to 12 pence per student per quarter. It caused a considerable loss to the plaintiff. Plaintiff sued the defendants. The court held that plaintiff had no remedy for the loss suffered by them. Next case is Mughal Steamship Company versus MacGregor Go and Company. The plaintiff and the defendants are the transporting companies. Number of steamship companies combined together and drove the plaintiff company out of the tea carrying trade by offering reduced freight. The plaintiff had no cause of action as the defendant had by lawful means acted and protected and extended his profits. Next case is Ushaben versus Bhagyalakshmi Chitra Mandir. The plaintiff sued for a permanent injunction against the defendants to restrain them from exhibiting the film named Jai Santoshima. Why? Because the film hurt the religious feelings of the plaintiff insofar as goddess Saraswati, Lakshmi, Parvati are depicted as jealous and were ridiculed. Request of the injunction was rejected. Another case is Action versus Blundell. The defendants dug a coal pit of their own land. This affected the plaintiff's well at a distance of about 1 mile. Defendants held not liable. Digging a coal pit intercepted the water. Inconvenience to the neighbor falls within the description of damnum sine injuria, which cannot become a ground for action. Next case is Chasmore versus Richards. The plaintiff was the mill owner. He was using water for his mill from a stream which was fed by rainfall. The defendant sunk a well on their land and pumped large quantities of water. The flow of water to the plaintiff was reduced. This caused loss to the plaintiff. The defendants, it is held that defendants were not liable. Vishnu versus Board of HS Intermediate Education UP. Vishnu, an intermediate student, was detained for shortage of attendance. Attendance register of the college were not maintained according to the regulations of the board. As a consequence of the detention, he lost 1 year. He made a case. His action to claim compensation for the loss of 1 year was not allowed as the plaintiff's claim did not fall under any of the heads recognized in. Next case is Town Area Committee versus Prabhudayal. Plaintiff constructed a building without obtaining a proper permission from the Town Area Committee. The plaintiff constructed 12 shops on the old foundations of a building. The said construction was made without giving notice of intention to erect a building under the Act and without obtaining necessary sanction required under the Act. The Town Area Committee or the defendants, they demolished the constructions. The plaintiff alleged that there were personal grudges between him and some of the officers of Town Area Committee. Because of that, they caused the demolition and their act was malafide. The defendant proved that construction was made without giving notice of intention to erect a building under sections 178 of the UP Municipalities Act, and they constructed without obtaining necessary sanction required. It was held that defendants were not liable in no injuria could be proved. The demolition of illegally constructed buildings would not amount to causing injury to the owner of the property. Now third aspect is the remedy. It is a loss or injury suffered due to the wrongful act of another. The sum of money awarded by the court to compensate to the damage is called unliquidated damages. Municipal Corporation of Delhi versus Subhagwati. A clock tower situated opposite to town hall. The tower collapsed as a result of number of persons died. It was under control of the municipal corporation and it was 80 years old. It was found that normal life of the structure of the building could be only 40 to 50 years because the kind of mortar used to evidence is that the top mortar was deteriorated. Delhi Municipal Corporation was held liable for damages.